Okay, so hi everyone. In the last class, we are talking about the rescission of the contract, and in that course, we have understood about the consequences of the rescission of a void contract and a voidable contract. Okay, and we have discussed that how the rescission of a voidable contract becomes effective. That means when we are talking about the rescission of a contract or denial of a contract, then how does it becomes effective? And if a person has taken benefit from that voidable contract or void contract, what is the next circumstances for that? We have already discussed that. Okay, and under that we have discussed that under section 64 we have talked about the voidable contract, and under section 65 we have talked about the void contract. Okay, so we have studied that when there is the rescission of a voidable or void contract, when the rescission takes place, okay, after the rescission of the contract, if any of the party has taken any benefit from that specific contract, the party is bound to pay back the specific kind of the contract or to return that specific kind of the contract. That is called the rescission or negotiation of the contract that we have already discussed under the Indian Contract Act. Okay. So, so under section 66, we have discussed what is the mode of revoking the rescission of the voidable contract. So when we are talking about the revocation of rescission of the voidable contract, that means rescission means we have understood that the denial or the negotiation is called the rescission. Okay, yeah, rescission means the revocation, cancellation, or the repeal of the contract. Okay, so when we are talking under section 66, the mode of communicating or revoking rescission of a voidable contract. So when there is a voidable contract, okay, and the contract is supposed to be rescinded or negotiated, okay, that is called the rescission of the contract. For example, you and me are entering into the contract, and the contract is about the dealing of a specific kind of the drugs. But afterwards, after the contract has been done, we got to know that the drug is no more allowed in India. That means the specific kind of the drug is prohibited in India. So now the contract was not void ab initio because the transaction of that specific drug was allowed in India before. But after the agreement between the parties, after the mutual uh, contract between the parties about the transaction of the drugs, the contract became voidable in nature. Why so? Because those specific kind of the drug, the selling and the buying of the drug, it became illegal in India. Okay. So when the selling and buying of the drug became illegal in India, and that is called the rescission of the contract. Got it? In that specific circumstances, in that specific case, when we are talking about the rescission, that means the negotiation or the denial of a voidable contract. That means the another party is refusing the sender or the person who is providing the drugs, or you can talk about the promisor itself. The promise is rescinding the promisee or the promisor is rescinding the promisee, or the promisee is denying the promisor about the applicability of the contract. That see, this contract is not enforceable anymore. This is voidable in nature. So here, when a contract becomes voidable now, then it is the discretion of the party suffering, the party who is suffering due to the voidability of the contract. This is the discretion of the party to decide whether the contract should be continued or the contract should be terminated. Okay. So, when we are talking about the voidability of the agreement of the parties that the contract should be enforceable or the contract should be terminated as per the nature, the party who is suffering, he or she has the power to take the decision. Okay. So, for example, there is the contract of the drugs about the buying and selling of the drugs, as I was talking few time before. So let's take an example. I am the party who is providing the drugs, and you are the party who is receiving the drugs. So when the contract became voidable in nature, you are the party who is going to gain the loss because you are the promisee or you are the receiver of the property. So it is your discretion to declare the contract voidable or to continue the terms and conditions of the contract. But you decided to resign the contract, to do the rescission of the contract. You decided and you thought that no, I don't want to continue the contract anymore, or I want to terminate the contract over here. So it is your decision to do the rescission of the contract. According to section 66, when we are talking about the communication or revocation of the rescission of the voidable contract, that means communication of the rescission of the contract. That means I don't want to continue the contract or I want to terminate this contract. This is called the communication of the rescission of the contract. The rescission of the contract or the denial of the contract is being communicated. Revocation of the rescission of the contract means I am revoking the rescission. That means I am accepting the contract. So, when you're talking about the voidable contract and the rescission of the voidable contract, it means the party is itself saying that no, rescission of the contract means the party is denying or rescinding to continue with the contract anymore. Yes. But revocation of the rescission means the party is revoking or denying the denial of the contract. That means the party is accepting the contract. Yes. So, under section 66, we have talked about the process of this acceptance or revocation of the rescission. How does it work? It works according to the section 4567 we have understood under this Contract Act before. The rules that is applied to the communication and revocation of the proposal. The same rule is applicable under section 66 of the Indian Contract Act itself. Then the next point we have understood under section 67 that effect of neglect of promisee to afford promiser reasonable facilities for performing. And under that we have understood it clearly that when there is the presence of the contract between two of the parties and one party is promising something to the another party, okay, but the another party is neglecting to perform his part of the contract or her part of the contract. For example, you are hiring me to do the repairing of your house, okay, so you have paid me 5,000 rupees in advance that ma'am, please keep this money and I want my house to be repaired. I want to do the interior decoration, designing and repairing of my house. So can you please come and do that? I said, okay, I'll do the work. So here I am ready to do my part of the performance. I am ready to work for you, to do the designing for you. I'm ready to do that. But you are not cooperating me. I have asked you 3 times, 4 times, 5 times. Can you please send me the decoration design of your home? Or can you send me the pic of your home? How does you want the house to be decorated? Or what kind of repairing you need in your home? Can you please clarify it? Even after my questions to you, even after my uh, attempt to do or to perform my duty in your house, you seems not interested on this, or you are not showing your interest in the contract, or you are avoiding the contract, or you are ignoring the contract. So in this circumstances, the party, if I am not doing the performance of the contract, then I am not liable for this non performance, because this non performance is being caused by your negligence or refusal. I am not the reason for this non performance of the contract. The reason for the non performance of the contract is you only. When I needed your support, or when the party needs the cooperation of the another party to complete his performance, this is the duty of another party to cooperate. And if the party is not doing his duty, then in that circumstances, as a promisor, I am not liable to perform my contract if the situation is not cooperating me. And that is why in this case, or in this section, the promisor is not liable to do the non-performance of the contract if the non-performance is caused by the neglect or refusal of the promisee. Got it? Then comes chapter 5. And under chapter 5, we have discussed about the relations resembling those created by the contract. Okay, that we have understood under section 68. Okay, so what does it mean? If a person incapable of entering into a contract, or anyone whom he is legally bound to support, is supplied by another person with necessaries suited to his condition of and condition in life, the person who has furnished such supplies is entitled to be reimbursed from the property of such incapable person. Under section 68, I have explained two situations in the last class. In the first situation, I told you when the person is unable to take care of himself and his or her family. For example, the person is mentally ineligible to take care of the children, or the person is physically handicapped, the person is mentally disturbed. Okay, so in that circumstances, when the person is incapable to take care of himself, in that case, when any other person, it might be inside the relative or outside the relative, always it doesn't matter that the person who is taking care of the family or taking care of the person who is lunatic or who needs help is need to be the family member of the person. No, it is not needed. Any outsider can also do this service and can be the part of this section under section 68. Sorry, under section 68 of the Indian Contract Act. Okay. So when we're talking about the person who is lunatic or mentally disturbed and the person is incapable to take care of his own expenses, the person is incapable to do his own stuffs by himself, then if any person is taking care of that specific person, or the expenses of the person, the family of the person, then in that circumstances, the person who is doing this service, it is not for free. And the person who is doing this service is liable to get the specific amount from the property of that specific person. So this can be extended to another situation over here. Another situation what we have discussed. For example, there is a person who is lunatic by nature, and the lunatic person is having his one wife and three children. Okay, so as we know, the person who is lunatic by the nature, that person is incapable to take care of his family. Obvious बात है, the person who is lunatic or the person who is mentally disabled person, how can that person take care of his family? He just cannot do that. Okay, so when the person is himself incapable to take care of himself, as well as incapable to take care of the family of the person, or it is applicable to the all situations when the person is staying alone, or the person is suffering from any kind of the disease and unable to take care of himself. The second situation, when the person is dead, the wife and the children of the person is unable to be taken care of. The wife and the children are at the mentally incapable person, or the person who is dead, they are suffering from the financial issues, or they are suffering from a lot of issues. So if any other person outside the family, it might be the close relative, or it might be the far relative, or it might be any other person who is known to them, if if that person is doing those kind of the service, it is justified that the person who is doing that service is capable to gain the benefit from the specific property. That means, uh, that means if the person is having the property of 5 lakh of the rupees, and if it is estimated the person has been got the benefit around 3 to 4 lakh from the property of that specific person, okay, or from his dead, from the dead, after the dead husband, if he is taking care of the widow lady and their children, then whatever the situation demands, for example the child care of the children, or the educational background of the children, to take care of the wife. Okay, so when we are talking about, all these situations, the person is and the person is providing all kind of the support to the family of the dead person or lunatic person. And after providing all kind of the support, the person should not be left with the vacant hand. He must liable to get certain kind of the compensation from it. For example, even if the person is a debarred person, or if the person is a lunatic, or if the person is having no money or bankrupt, that is a different situation. Okay, or if the person is doing all this kind of the service out of love and obligation, that is something different situation. But if the person is doing those kind of the service with a intention associated with it, the property, or with the person is capable to gain the benefit from the property of that specific person itself according to Section 68 of the Indian Contract Act. And specifically, talking about the property of that specific person, whatever is the amount of the property, if it is 5 lakh of the rupees, the person is liable to get the share amount according to his expenses. Okay. Sometimes it happens that the property of the dead person or lunatic person is not that much sufficient that the expenses done by this person can be covered fully. But it is not always expected that all the expenses can be covered fully. It can be covered partially, and if the uh, amount of the property of the deceased person or the lunatic person is more than sufficient, then yes, the expenses can be recovered fully. So it is the total discretion that what is the amount of the property and how does it works. It is the discretion of the court to decide that. Okay. Then comes section 69, reimbursement of person paying money due by another in payment of which he is interested. Kavita, are you there? Hello, am I audible?
हाँ मैम बोलिए।
हाँ, कॉल किया था।
आपको कॉल गया है?
हाँ हाँ, मुझे तो अभी एक कॉल आया, मिस कॉल दिखा रहा है।
अच्छा अच्छा, पता नहीं गलती से गया होगा, सॉरी मैम।
अच्छा ठीक है।
कंटिन्यू करिए।
नहीं 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 नहीं, सॉरी, और किसी का कॉल आया था, मुझे लगा तुम्हारा कॉल है। चलो ठीक है। हाँ, सो according to section 69, we have talked about the reimbursement of person paying money due by another in payment of which he is interested. Okay. So under this, we have discussed that a person who is interested in payment of the money which another is bound by law to pay and who therefore pays it is entitled to be reimbursed by the other. This section is very simple. Let's understand this step by step. For example, I am the landlord of a property, okay? And you have taken my home as a rent, okay? So what happens that you have taken the okay, sorry. So you have taken my property, you have taken my home as rent, okay? And you are staying at my home as per the rent. You are paying a certain amount of 3,000 or 5,000 to me as per the monthly basis, okay? That is happening according to the first circumstances, okay? Then comes to the next step. What is happening? That the person is always month to month you are paying me the rent amount and everything, okay? But suddenly at a time you are getting a notice from the government that the house or the home where you are living, that home is with the debt from the government of 3 lakh of the rupees, okay? So what you got to know that the home where you are staying as a tenant, that home is with a due debt of 3 lakh of the rupees which was supposed to be repaid by the landlord or by the owner, that is me, okay? But I am not available at that particular of the time. I'm not at India at this point of the time to repay the debt. And you are seeing that if the debt amount is not being repaid, if the amount of 3 lakh is not being repaid, then the house will be uh, taken by the government. The government will take over that specific property if the specific amount is not been repaid. Okay. So what is happening when the amount is not repaid? And you see that the circumstances are like if the amount is not repaid, the government will take over the property, and the owner or the landlord, whoever it is, the person is incapable to come India at this point of the time, or or he is suffering from any kind of financial crisis or anything. He is just incapable to do the payment. वो पैसा नहीं दे सकता. That is the clear scenario. Okay. So to stop the takeover of the property, to stop the selling of the house to the government, what you did, you gave government 3 lakh of the rupees on behalf of the owner. आपने वहां पे क्या किया, जो 3 लाख रुपया ओनर को देना था या लैंडलॉर्ड को देना था, उस अमाउंट को आपने खुद पेमेंट कर दी, विथ द इंटेंशन और विथ द होप कि अगर आप पेमेंट कर देते हो तो आपका ये जो घर है ना, वो बेच और और बेचा नहीं जाएगा, और द गवर्नमेंट इज नॉट गोइंग टू टेक ओवर द प्रॉपर्टी एनीमोर। तो अगर हम लीगली देखते हैं तो उस घर का जो भी टेनेंसी है उसका, you are just a tenant over there, so you have all the responsibility to pay the tenant only, to the pay the monthly fee only, but you are not responsible over here to pay the amount of the 3 lakh to the government as the revenue amount, जो कि आपको नहीं पे करना था, but you did it just for the sake to save your own house। आप वहां पे रहते हो, आपने यहाँ पे देखा कि अगर आप पेमेंट नहीं करते हो तो गवर्नमेंट ये प्रॉपर्टी को टेक ओवर कर लेगा, एंड मेरे पास तो अभी रहने के लिए दूसरा कोई घर है नहीं, तो मैं रास्ते पे आ जाऊंगा, तो मैं क्या करूं, मुझे अभी ये 3 लाख रुपया पेमेंट कर देनी चाहिए जो कि ओनर को करना था। तो यहाँ पे आपने पेमेंट कर दिया, तो व्हाट इज नेक्स्ट, आर यू लायबल टू गेट द अमाउंट फ्रॉम द ओनर? द आंसर इज यस। जो पेमेंट मेरे को करना था, जो पेमेंट ओनर को करना था, उसी पेमेंट आपने किया है। सो एज अ रिस्पॉन्सिबिलिटी, एज ए ड्यूटी बाय द ओनर, you are responsible or you are liable to get the specific benefit from me, or you are responsible over here to uh, to get that 3 lakh of the amount from the owner or from the landlord itself। आप यहाँ पे लैंडलॉर्ड से और ओनर से वही 3 लाख रुपया पाने का हकदार है, बिकॉज यहाँ पे ये जो 3 लाख रुपया आपने पेमेंट किया है, दैट वॉज नॉट फॉर योर सेल्फ। आप तो वहां पे टेनेंट है, आज आप वहां पे रह रहे हो, कल और कोई दूसरी जगह पे चले जाओगे, बट परमानेंट बेसिस पे वो जो लैंड है, वो जो घर है, वो किसका है, और तीसरा कोई इंसान का है। यू आर नॉट द रियल ओनर ऑफ द होम, but just for the sake to save your rented property from being sold and to save your owner or the promiser of the home, you sold what did you do, you paid the revenue amount and saved the house from being sold। Got it? So in these circumstances we can speak that the person paying monthly due by another, sorry, obligation of the person, we have understood that when there is the reimbursement of the person paying money due by another, that person is liable to get the payment of which he is interested. That means if the person is paying the reimbursement amount of the specific property or land to another person or to the government, to anyone, to secure the property or to ensure the security of the property, then in that specific circumstances, we can understand that the person paying money due by another, he is liable to get the repayment of this, okay, and he is liable to get the exact or to recover the whole amount of his or her expenses, because this is not his own benefit, this is the benefit of the owner, and the owner has to compensate him or her the full amount itself। okay, तो ये हो गया आपका सेक्शन 69। देन आपका आता है सेक्शन 70। सेक्शन 70 स्पीक्स अबाउट द ओब्लिगेशन ऑफ पर्सन enjoying benefit of non gratuitous act. Okay, so what does it mean? Where a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and such other person enjoys the benefit thereof, the latter is bound to make compensation to the former in respect of, or to restore the thing so done or delivered. Okay, so when there is the non gratuitous act by someone, gratuitous act means, just like I told you few time back, I am paying you something for a specific kind of the work. That is called the gratuitous work. जैसे कि मैंने अभी थोड़ी देर पहले बताया कि मैंने आपके लिए 3 लाख रुपए का पेमेंट किया, आप मुझे 3 लाख रुपया वापस करोगे. That is called the nature of the gratuitous work. So when there is the presence of the non-gratuitous works, that means when um, there is a situation where the person has not done anything with his intention. For example, uh, I have visited your home. मैंने आपका घर गई हूँ घूमने के लिए, घूम के देख के आने के लिए. बट आपके घर पे बैठते बैठते मेरा जो घड़ी है ना, मैंने उसको क्या किया, आपके पास रख के आ गया. I left my watch at your home. So that is called an action of the non-gratuitous works. That means यहाँ पे you know well कि this watch belongs to the another person. This is not my watch. So I should not enjoy the benefit of this work. And even I know I am the owner of the watch and I am supposed to hold the watch. I am supposed to carry the watch and I am supposed to wear the watch. You don't have any right on my watch. So when I am leaving my watch at your home, जब मैं गलती से आपके घर पे मेरा घड़ी जो है उसको छोड़ के आ जाती हूँ, then what is the circumstances for that? You tell me. Here the answer is very simple. Okay, where a person lawfully does anything for another person or delivers anything to him, not intending do so gratuitously, such other person enjoys the benefit thereof and latter is bound to make the compensation to the former in respect, or to restore the thing so done or delivered. What does it mean? That means when the person has enjoyed the property of the another without taking consent or without former in respect of that specific person, in that circumstances the compensation or the latter bound to make compensation to the former or to restore the thing is so done or delivered itself. Okay, that means, for example, take an example of this. um, A is a tradesman. He leaves good for B's house by mistake. B treats the good as his own. He is bound to pay A for them. For example, I am the person. I have gone to your home to do a visit. Okay. During my visit, what I did, I have opened my work, or I started doing my work. So in the work pressure, I left my watch at your home, which I am totally unaware about the fact. So the point is, here you can enjoy your own property, but you cannot enjoy the property of another. When I am leaving my watch at your home, you are supposed not to enjoy the benefit of my watch. Yes or no? You are not supposed to enjoy the benefit of my watch. So when you are unable to enjoy the benefit of another person's property at that specific circumstances, if you are doing so, if you are enjoying the benefit, then you have to repayment or you have to recover that specific benefit gained thereof. So yeah, so what happened that when I left my watch at your home and I came back to my workplace and I started doing my work, and after 1 to 2 months, when I remembered that yes, there was one watch of mine, मेरा एक घड़ी था, मैंने उसको कहाँ रखा? ढूंढते ढूंढते मेरे को याद आया कि मैं तो घड़ी आपके घर पे ही छोड़ के आ गई हूँ. And when I asked about that watch to you, then I got to know that you started using my watch as your own. आप मेरा घड़ी को अपना घड़ी जैसे यूज करना शुरू कर दिए हो. So this is the एग्जाम्पल ऑफ नॉन ग्रेटुटियस वर्क. मैंने आपको यहाँ पे मेरा जो घड़ी आप यूज कर रहे हो, इज इट विथ माई ड्यू परमिशन? द आंसर इज नो. मैंने आपको यहाँ पे कभी बोला नहीं कि मेरा घड़ी आपने यूज करो करके, बट आपने मेरा घड़ी विदाउट माई परमिशन नॉन ग्रेटुटियसली यूज कर रहे हो. एंड जस्ट बिकॉज I have forgotten this and I have left that watch at your home with a mistake. So in this circumstances, this is an example of the non-gratuitous work, and you have to pay me or compensate me for the benefit you have taken from my watch along with returning my watch. Got it? तो ये हो गया सेक्शन 70. देन आपका आता है सेक्शन 71. दिस स्पीक्स अबाउट द responsibility of the finder of the goods. When one person who finds the goods of another and takes them into his custody is subject to the responsibility as a bailee. So we have understood about the concept of the bailor and bailee. We have understood that when there is a person, for example, what is the concept of bailor and bailee? मेरे पास कुछ सोना है, मैं 2 महीने के लिए बाहर जा रही हूँ, and I want to save my goals. तो मेरा डर है कि अगर मैं अपने घर पे ही वो सोना छोड़ के चला जाऊंगा तो मेरे घर से वो चोरी हो जाएगा. तो मैं क्या करती हूँ, आपके घर आती हूँ, आपको ये सोना दे के जाती हूँ कि आप मेरा सोने का थोड़ा ख्याल रखो 1 महीने के लिए, मैं वापस आके ये सोना आपसे ले जाऊंगा. सो हियर आई एम गिविंग दैट गोल्ड टू यू, not to use, just to take care of it. So here I am the bailor who is providing my property to you to take care of it, and you are the bailee who is taking care of the property. Here, if you are getting a belonging of another person, for example, I lost my watch, I lost my purse, I lost my card somewhere, and you are getting this, you are calling me that, ma'am, I have received your thing from somewhere, you lost it. So until and unless I am receiving that specific product or that specific goods from you, जब तक मैं वो प्रॉपर्टी या मैं वो सामान आपसे नहीं ले लेती, तब तक you will act as the bailee of that property. You will take the responsibility as a bailee. आप उस चीज का देख रेख करोगे, आप उस चीज को संभाल के रखोगे, बट आप उस चीज को यूज नहीं कर सकते, बिकॉज आई एम द ओनर ऑफ द प्रॉपर्टी, नॉट यू. That is explained under section 71. And the last portion, section 72, it speaks about the liability of a person to whom the money is paid or thing delivered by mistake under coercion. What does it mean? A person whom money has been paid or anything delivered by mistake or under coercion must repay or return it. For example, बाय मिस्टेक और कोयर्सन, यहाँ पे दो चीज के बारे में बता गया है. पहला ये है कि मिस्टेक मतलब गलती से, कोयर्सन मीन्स बाय फोर्स. ओके, आप मुझसे 2000 रुपया का लोन लिए थे. ओके, तो अकॉर्डिंग टू द लॉ आप मेरे को 2000 रुपया ही रिपेमेंट करोगे, बट मैंने आपको कॉल पे बोला कि सर आप मुझसे 3000 रुपये लिए थे, आप मुझे वापस कर दीजिए. आप भी भूल गए हैं कि आप मुझसे 3000 लिए हैं करके, तो आपने क्या किया, मुझे 3000 रुपया वापस कर दिया. बट आफ्टर द पेमेंट यू रिमेम्बर दैट ओ सॉरी, मैंने तो मैम से 2,000 रुपया लिया था, तो 3,000 मैंने क्यों दिया? So here I am responsible or I am liable to pay you back that extra amount of 1,000. और मैं आपको कॉल करके धमकाती हूँ, अगर आप मुझे 2,000 की जगह 5,000 वापस नहीं करोगे तो मैं आपको पुलिस केस में फंसा दूंगी. With fear, you are paying me the amount of 5,000. So this section is also include as a coercion. यहाँ पे आप जबरदस्ती मेरे को पैसा दे रहे हो. So I am liable or I am responsible to get that specific amount which I am capable of, not more than that. अगर अंडर द कोयर्सन और मिस्टेक आप कुछ भी सामान या पैसा किसी को भी डिलीवरी कर देते हो, देन द पर्सन to who has received the extra goods or extra money is liable to return it or is liable to do the refund of it because he or she is not the original owner of that property. So this is about section 72. Next, we will understand about the chapter 6, and that speaks about the consequences of the breach of the contract, and that we'll start discussing in the next class. This is all for today, guys. We can drop the class over here. Thank you. Take care. Bye bye.